Hello everyone, I am Scott Aubrey from Aubrey Law, and I'm super excited to be with you today. And today I'm going to talk about what is a will. But before I get started, if you have any questions about what I talk about today or about estate planning in general, then you can go to estateplanmeeting.com and schedule a time to talk with me for free. Again, that is estateplanmeeting.com. So today's topic is what is a will. I think most people know that a will is something used to determine what happens to your stuff after you die. However, there are some things that a will can do and some things a will cannot do. Your will only comes into effect is after you die. That's the only circumstance which your will comes into effect. However, if you don't have a will, then certain decisions will be made for you, either by a judge or by state law that determines what happens to people's assets if they die without a will. So it's important to remember that there are certain things that a will can do, and there are really three important things that a will can do. The first thing a will does is it names a person who is responsible for administering your estate. And what does that mean? This person is responsible for gathering your assets, identifying and paying off your debts, and then distributing your assets according to your will. The second thing a will does is if you have children under 18, it names a long-term guardian for your children. So if something were to happen to you and your spouse, or just you if you're a single parent, then who is going to take care of your children? You can do that in a will. You can name that person who will be your choice for taking care of your children, and no one can fight that. So as long as the requirements for a valid will are followed, then your choice for long-term guardian will be honored and no one can fight that. However, if you don't have a will, then that decision for who take care of your children will be made for you. It will be made by a judge who doesn't know anything about you, doesn't really know anything about your children, and can only really make his decision based on the information that is presented in front of him. So what I kind of tell clients in potential meetings is that think about the person who looks really good on paper, but may be the last person that you would want be taking care of your children long term. So that person may present really well to a judge, but that would be the last person that you would choose. So if you don't want that situation to happen to you, then you need to have a will that chooses the guardian for your children. The third thing the will does is it says what happens to your stuff. In your will, you can determine who gets what, right? For the most part, if you don't have a will, then state law determines what happens to your assets, and they will be given to you basically to your lineal descendants. So if there's someone that you wanted to give something to that was not a lineal descendant, then you need to have a valid will in order for that person to get that asset. So those are the three important things that a will does. It's the foundational piece of an estate plan. Everyone should have a will. So if you don't have one, you should really consider about getting one. So that's what I have all you for today. So again, if you have any questions about what we talked about today, you can go to estateplanmeeting.com and schedule time to talk with me for free. Again, estateplanmeeting.com. If you like this video, you hit the like button. If you know someone that could use information I talked about today, please share that with them. If you have a comment or a question, please leave it here and I'll be happy to respond to you. So again, thank you for joining me, and I'll talk to you soon.